Good morning, everyone, and welcome to the first presentation for this morning. I won't go through the bio of the speakers. You can read all that on the app. The topic is preparing for Australia's mandatory data notification. What does it mean for business? And we've got speaking today Ben DeMarco and Matthew Pokarier. Without further ado, I will leave you with the presenters, and remember, you can leave feedback and post questions using the app.
Good morning, everyone. Welcome to the first session. Ben and I presented at this conference last year, and at that time, we anticipated the potential arrival of the mandatory breach notification laws for data breach. Some predictions come true, some don't. This one has, and this is going to become law around the 22nd of February next year. There are two parts to our presentation today. I'll be taking you through the somewhat dry issue of what the law means, and Ben will be taking you through the second part, which is what the impacts might be on business and what you can expect in the nature of business imposts as a result of this law. We talked last year about the general privacy provisions, and this law needs to be seen as an addition to that. Certainly there have been privacy obligations on organisations for a long time, and that's been regulated by the Privacy Act. This adds a further dimension to that Act. So I'll just get this working in a moment. As I said, it all takes effect from the 22nd of February, and it imposes a new regime of obligations. Previously, Australia hasn't had any obligation to notify of a data breach, except if you are working within the health sectors. There have been obligations in that regard for some time. The notification law has a very broad application, and it's going to capture most Australian organisations. I should mention that we've also prepared a fairly detailed paper on this subject. It'll be on the app or online sometime after the presentation. What I'll be doing today is going fairly briefly over these issues. If you want a deep dive on any particular issue, please, you'll probably find the answer in that paper. All right, why does data notification law matter? I mean, historically, there's been very limited reason for organisations to report data breaches. And it's widely suspected that a very large population of data breaches has occurred in Australia and has not been reported. Now, obviously, the whole idea is to protect individuals on the assumption that those at risk of harm from a disclosure of their personal information can best protect themselves if they're aware that someone's had access to it. And the sooner that happens, the better. There's an added factor of increasing the wider community's awareness of data breaches and data security as a general issue, and the consequential risks and the significant financial impost of identity fraud and fraud generally. And the fact is there'll be a real financial consequence of these laws. They mirror the impact. We've seen this mirrored in other jurisdictions, particularly the US. Almost across the world, data notification laws have been brought into being or in the process of that occurring. And in every jurisdiction where that's occurred, we've seen a significant increase in costs associated with the loss of private information. Now, what is it in a nutshell? There's really three basic concepts you need to grasp about the data notification laws. Firstly, they obviously apply to a very wide range of data breaches, from simple things of, the loss of USB or laptops with important documentation and information on it, to intrusions, to accidental exposures of the data. It's quite a broad range. But in assessing what's notifiable, we need to look at three primary issues. The first is where there's a suspected unauthorised access or an unauthorised disclosure, you have to determine if there has been an eligible data breach. It's this beast that's the sort of a key trigger to this legislation. Now, to determine if you have an eligible data breach, you need to decide whether the incident's likely to result in serious harm to any individuals. If that's the case and you reach that determination, then you have a two-tiered obligation to notify. The first notification is to the regulator, the Office of the Australian Information Commissioner, and you also have to take steps to notify individuals whose data has been impacted. Now, as I said, this has broad compass. If you're an existing APP entity, it applies to you. It applies to credit providers, credit reporting bodies, file number recipients. It broadly applies to most government agencies, private sector organisations with a turnover above $3 million, and a whole bevy of smaller organisations. I mean, the simple test is if you hold data in the way you do business that's of a private nature, then this will apply to you. The most obvious example is, for example, health records. This whole regime is regulated by the OAIC. Now, the Commissioner has had this obligation under the Privacy Act for some considerable time. This legislation builds on an existing bedrock of privacy legislation, and it fits within a lot of the other provisions of the Act. The Commission has always had the capacity to undertake investigations into privacy breaches, and this Act brings a breach of these new provisions into the existing compliance obligations. So you become exposed to all the other powers the Commissioner has previously had, including the civil penalty regime, which provides for fines of $340,000 for individuals and $1.8 million for corporates. We can expect, however, that the Commission is not going to take a brutal approach to this legislation, at least in the short term. I think the Commission's in the educative phase is trying to bring corporations and organisations up to a level of understanding of what's required under the Act. So I think it's very important to keep an eye on the Commission's website over the next few months up to the implementation of this legislation, because we can expect guidance principles to be published over the next few months. What we can expect, however, is at some point in the future, the Commission is going to become less soft and much more hard about compliance with these provisions. Now, this all turns on personal information. It's what it's all about. So we need to understand, what is this personal information? Now, we look at this in quite a lot of detail in our article, so I'll go quite briefly through it, but it is very important as an organisation to have a good understanding of this issue. Now, somewhat simply, it is defined in the Act to mean information or an opinion about an identified individual or an individual who is reasonably identifiable. Now, it doesn't matter whether the information is true or not, and it doesn't matter if it's recorded in material form or not. By way of example, it includes sensitive information. There's a wide gamut of what that might mean. Lawyers love terms like sensitive information. It keeps us in business. But it certainly includes information about your political alliances, your ethnicity, your employment records, your sexual preference, your voting intentions, that whole gamut of information that's relevant to you as an individual. I mean, it obviously also includes health information, credit information, and employee records. All right, let's look at how the data notification law works within the existing Privacy Act, because it's very simple to look at this as a notification obligation in certain circumstances. But there are existing obligations under the privacy legislation that have been there for some considerable time and may not have received the workout they might receive now that the Commissioner has this resource, which is formal notification of every data breach that might cause harm to individuals. Now, under the Australian Privacy Principle 11.1, this is where entities receive an obligation to look after the personal information that they have. They have to protect it from misuse, interference and loss, and from unauthorised access, modification or disclosure. 8.1 extends that in the sense that it provides an extraterritorial element to it. So if you have that data and you provide it to an overseas recipient, you have to ensure that overseas recipient also protects that data. So if you have external data storage facilities overseas, your obligations aren't removed as a result. 6.1 says that an entity holding that personal information can only use it or disclose it for the particular purpose for which it was collected. There's an extension to that also where once your use of that data has expired or you no longer need it, you have an obligation to destroy it. Now, the concern we have here is that the existing legislation now requires you to notify data breaches. In the circumstances that occurs, there's simply nothing stopping the Commissioner from looking, and is likely to, look at some significant detail as to the extent to which you as an organisation have complied with the existing privacy principles. So it probably extends the vulnerability to regulatory action to most organisations as a result. Now, what's an eligible data breach? This is the thing that triggers your obligation, and I've spoken very briefly about it, but it's worth having a closer look at. Now, it contemplates two events. You have to have an unauthorised access to or disclosure of personal information, and we've talked about what that personal information looks like. And where there's been a loss of the personal information, including instances where exposure of it's likely to occur, we have to look at whether a reasonable person would consider that's likely to cause serious harm to any of the individuals to whom the information relates. Now, assessing that risk of harm is obviously critically important. Now, an entity has an obligation to conduct a reasonable and expeditious assessment to determine whether there is a likely risk of harm. Now, let's have a look at what some of the risk assessment factors include. It's obviously relevant what the type and sensitivity of the information is. I mean, some of this is pretty obvious if it's health records, for example, but that isn't always clear. We have to look at whether the information was protected by any security measures and the likelihood of those measures being overcome. That may be encryption or some other form of protection. The nature of people who have obtained or could obtain the information. Information can be disclosed to a trusted source, and that would be less an indication of potential harm. But then equally it might go to the public at large or to a source that was subject to criminal activity. The likelihood that third parties could obtain the information or circumvent any security technology or method used to encrypt the information. And the nature of the harm itself is also important. In Australia, we expect that to have very broad compass. That would include, obviously, financial harm, exposure to fraud, but equally someone being subject to personal distress, to psychological injury, to being subject to humiliation or some other form of attack. There are some other relevant matters too that need to be considered. Obviously, the duration of the exposure is important. If something was exposed on a website for only a short period of time, that's less important than if it had been there for months. Whether there's any evidence of misuse of that information, whether, for example, records have been found on the dark web for sale, that would indicate a very high likelihood of harm. If the information was accessed intentionally by an employee or otherwise, that would suggest some deliberation in the intrusion and then, again, an increased prospect of harm. If the information relates to vulnerable groups, for example, if it was about a women's shelter, if it was about a vulnerable ethnic group, then that would again be a trigger that would say, well, harm's a likelihood in this case. Now, there's an assessment timeframe applied under the Act, and it's basically 30 days. I mean, this isn't a hard and fast timeframe, but it is an expectation of the Commissioner that really it should be possible to take all reasonable steps to assess this harm component within that period of time. But that might depend on the complexity of the intrusion. It also might depend on the resources available to an organisation to respond. Now, in circumstances where an organisation first becomes aware of the incident, and if you think there's reasonable grounds to believe there's been an eligible data breach, and this can happen quite quickly in some circumstances, then the assessment timeframe provision may not apply, and you move straight on to the notification side. Now, the notification process itself. You need to notify the Commissioner, and you also need to notify affected individuals. I mean, the Commissioner is probably more straightforward and easy. You provide a notification statement that has to contain the identity and contact details of the entity, a description of the eligible data breach, and your understanding of how that's occurred, the kind of information concerned, that's the information that's been disclosed, recommendations concerning the steps that individuals can take to mitigate their loss. So there has to be a helpful component to this, the ways in which you think this can be remediated. And the identity and contact details of any other affected organisations, because you can have multiple organisational disclosures and breaches. All of that has to happen as soon as practicable. It's another great term lawyers love because it means there's some uncertainty, but the reality is this has to happen pretty quickly. Now, you don't have to do this. There's an exemption from notification, and that exists if remediation is possible. Now, to remediate it, there have to be active mitigation steps that are taken by the organisation once you become aware of this breach. And as a result of these steps, a reasonable person would have to believe that the risk had been ameliorated. So in effect, you've fixed the problem. Now, it's probably going to be a fairly brave organisation that relies or places a high degree of confidence on the fact they've remediated a breach. And that would be something that you'd be carefully considered. It is possible, for example, where data's escaped and you've managed to have the recipients destroy it or some other technical solution has been obtained, but it's something that you want to be very careful about because the Commissioner may well very closely assess the reasonableness of your belief in that regard. You can apply to the OAIC for an exemption from the requirement to provide notification or for an extension of any of the relevant timeframes to do that. The Commissioner will have regard to issues like public interest, whether a declaration providing you what you want is reasonable in the circumstances, any relevant advice the Commissioner has received from enforcement agencies, and any other matters that are considered relevant. It's a fairly broad discretion. Now, the notification timeframes and obligations are suspended during the time of that application. As I indicated before, it's quite possible to have breaches by breaches impacting multiple organisations. Now, those breaches will potentially impose obligations on all of those organisations for the same breach. This is because the law fixes on whether you hold personal information, and more than one organisation can do that, particularly in circumstances where you rely on a third party, for example, to store data, but you maintain access to it to utilise it. In that case, you'll still be deemed to hold the information. If there is a breach, and it does have this multiple effect, however, if one organisation notifies in accordance with these provisions, that's sufficient for the purposes of the assessment. This, I think, really highlights the importance in the event of a multi-party data breach that the relationships and cooperations between organisations are fairly streamlined. You also obviously need to consider the contractual obligations and indemnities that are provided between organisations in that regard. I've mentioned the extraterritorial impact of the law, and overseas outsourcing obviously becomes an issue. So APP entities need to take reasonable steps to ensure overseas recipients of information don't breach these privacy regulations. Now, Australian organisations, as I've said, are still deemed to hold personal information if they maintain possession or control of that record, or have a power to deal with it, even if they don't have physical possession of it. These laws are extended into that same extrajurisdictional realm by Section 26 WC1 of the Act. Now, when an APP entity discloses personal information to an overseas recipient, or where a credit provider discloses credit eligibility information, the Australian entity will be responsible for any breaches that are committed. All right, finally, what should organisations do to prepare? Firstly, keep an eye on the Privacy Commissioner. He'll be producing some guidance in the near future, and that will be very useful. Know your data, know what you're storing, how you're storing it, and where you're storing it. Be sure to have incident response plans. They're very important. They need to incorporate the timeframe requirements under the Act. They need to identify how key decisions will be made, particularly in the triage phase of a breach. They need to incorporate contractual obligations. They need to deal with insurance obligations should you have cyber insurance. Your policies and procedures need to be polished and up to date, particularly with respect to how you store data. You need to be very conscious of the defence and preparedness of your organisations for dealing with data breaches. Testing is important. Penetration testing is relevant to this. Proper staff training is essential. And it's also worth looking at your risk management tools. Do you need cyber insurance? What other contractual protections should you have in place? Now, that quickly has dealt with the legislature itself. What Ben's going to do is run us through what some of the real business impacts are of these new laws.
Thank you, Matthew. So for my part of the presentation, we were talking a little bit amongst ourselves in the office about how can you give some guidance to companies on what the law is actually going to mean. Rather than being theoretical, the approach we ended up taking was speaking to some of our international colleagues and getting together some data on what actual breaches have cost, what some of the exposures were, what some of the tails are. In the paper that we've done, which for those of you that are gluttons for punishment runs at about 45 pages, there's a big explanation of how we got the data together, what we decided on, and how we ended up settling on these 30 matters. Essentially, these were matters that we had really good data for. They're from a variety of different periods, and what they also show is instances where there was a breach, there was exfiltration, and you had to get together a significant response capability. You'll see on this slide here that healthcare was one of the biggest represented categories. This reflects the fact that they hold significant amounts of valuable information. Medical fraud and identity fraud is commonly committed when you get access to that information, and also they operate in a very highly regulated environment. As well as that, in our sample we had a lot of retail and hospitality breaches, wide variety of organisations. Some were online traders, some were just simple stores that had point of sale style attacks, some were accommodation vendors, we even had a casino in the mix. We then had financial services and professional services firms. Amongst the very wide set that we initially looked at, there was a high concentration of these matters, but most of the matters that hit these organisations we found were ransomware. They tended to be relatively short tail, and you didn't really get that much good data from them. So for our next slide, here we've talked a little bit about, over all of the matters that we had, what were the percentage of costs that were being incurred. You'll see this is a slide that makes a number of the partners at my firm feel particularly comfortable and helps them sleep well at night. Legal costs is a very significant expense. There's a couple of reasons why we don't think you can make a straight analogy of that to the Australian setting, and we've actually made some deductions to that later on with some of the figures that we've put together. As well as that, forensics are substantive. They're not particularly huge. Part of that is because you tend to have a significant forensic cost in all matters, but rather than credit monitoring or notification costs, which rise based on the number of people that are affected, forensics tends to tap out at a certain level. Notification costs are a big component. This is the costs associated with informing people, but also being able to track to make sure you properly notified them, having call centres, having that type of management capability so you can deal with their complaints and their concerns. The only other one I'll briefly touch on is you'll see that for us, crisis management was not a significant cost. There's lots of talk of crisis management and crisis communication. They don't tend to relate as well to these incidents because you've got mandatory notification. The law kind of drives what your communication approach is going to be. So there's a limit to how much you can do in the crisis management outside of that. This slide here was just looking at each of the categories of costs and what the costs over time effect was. The reason why we did this was because historically people have said that these cyber incidents are very short tail. You have a lot of problems in the first few months, but they dissipate. Across our matters, that just wasn't borne out. There's a very high proportion of costs that you hit in the first 6 months. So particularly around your internal investigations, how you manage the notification process, how you go about informing people, giving them credit monitoring or some type of mitigation tool to protect harm. But really, for most of the categories, they continue well past a year. You can still incur forensics very late in the piece. You can have multiple waves of notification as you have to take additional steps to contact and inform subgroups, or as you might find out more information about a breach. And what's also very interesting is that the legal costs aren't huge at the start, but the problem with this is you get this perfect storm of investigative legal costs, you often have regulatory matters that you've got to deal with, and then you can have third-party litigations that will fall in at the tail. One thing that I will say about this graph here is we've probably understated the costs after 12 months. Some of the matters in the data set that we used were only 8 to 10 months old. So my suspicion is as we keep monitoring this, the further along you get, the higher some of those figures are going to get. Just to explain here, the first graph here is legal costs overall that we saw with all the matters. I've been told I've only got 10 minutes, so I'll try and hurry these along. Very simply, with legal costs, defence costs are a very, very big problem internationally. We don't have that much litigation yet that's sprung off from data breaches. So what we've done is all of our subsequent graphs and tables, we've cut out defence costs. And when you do that, your main concern is really dealing with the regulatory framework, your investigative costs, and sometimes what you need to do to set up privilege and protect sensitive documents. Legal costs over time. All I'm just going to say with this is you have some very significant privacy costs. That's what you need to do to determine your privacy obligations. But then what you have is later on, as your regulatory activity starts to pick up, there's a lot of legal costs associated with managing regulators dealing with their investigations. What we've also got, and there's a very detailed explanation of this in the paper, we've taken some specific sectors and looked at some trends and ideas of what we saw was happening with those matters. Healthcare to me is one of the most interesting ones. In all of the healthcare matters that we looked at, your costs to notify were very, very high, partly because there were a high number of people that could be affected, but also because they tended to place a lot of demands on you. So you needed to have good call centres, you needed to be able to deal with complaints, you needed to be able to direct them, and as well as that, they also had very, very high demands for credit monitoring. Credit monitoring is explained in detail in our paper, but essentially what it is it's the service that's provided by the entity after it's had the breach, so that any affected individual can go along, can sign up to one of these credit monitoring or identity protection services and can mitigate themselves against harm. It's a critical part of the breach response strategy internationally, and more there's a lot of talk about how you need to use it in the Australian context for data breaches. Retail and hospitality. Again, I'll be very quick here. Two things that are interesting about retail and hospitality. They have a very, very wide variety of exposures. PCI penalties, PCI assessments, those compliance costs can be a problem. As well as that, we see, again, legal costs are substantive, but we also see real levels of notification costs. We see a little bit more crisis management costs. The retail breaches overall were some of the most expensive breaches. That and healthcare tended to be the really, really big industries and the really big exposures. Professional services, these ones are quite unique in the sense that they have by far the highest level of forensics. We think the reason for this is because a lot of the breaches that were in our set, they had small internal IT teams, so they really needed to rely on their external vendors to gear up and to properly manage and triage the breach. For the final set of slides, what we wanted to do was we wanted to give people some idea of what happens depending on the severity of the breach and the incident that you've got. We put together 3 categories. So for us, the category of under 10,000 records, that was the more minor breach, the more simple breach to deal with. We had 9 of those in the total sample size. For us, the mid-level breach, we put it between 10,000 to 200,000 individuals' records being implicated. And we considered that to be mid-level severity. And you'll see here, once you get to that range, you have a much wider variety of exposures and challenges. And for us, we kind of thought the mega breaches or the really difficult breaches, they're the ones where you have over 200,000 individuals' records being impacted. They've got the widest exposures. They're also the ones that tend to be some of the most difficult to manage from a regulatory perspective because they get lots of media attention and they keep playing out in media cycles over and over again. Again, there's a good explanation of everything in the paper, so I'll skip ahead to some of the next slides. Cost breakdown over time for the 3 categories. The thing I'll just focus on here is for the over 200,000 breach category, it spikes in months 3, month 6 and month 8. Generally, month 3 is when you incur the most of your notification costs. Month 6 is when credit monitoring and some of those mitigation costs start to land. And month 8 typically is when the regulatory investigations start to heat up. So we'll expect to see similar spikes here when you have the big breaches. What I will say is the mid-category of breaches, we found they were quite active in the first 3-4 months, but then they drop off. And for the smaller breaches, again, it's not too inconsistent, but all of them have long tails. So all of them had costs that were being recorded after the 2-year mark. This one here is just to give a little bit of context in terms of average cost for breach size and for the categories. What I will say is when we first did the graphs, we did it in Australian dollars, but about 80% of the breaches that are in our set are US breaches, so we thought it was more consistent just to show it in US dollars, and that's what these graphs show. You'll see that for the simple breaches, your legal is a little bit over $80,000 on average. That comes up to about 120 Australian, 80,000 US, 120 Australian. Your forensics about 60,000 US. For the under 10,000 breach records, your total costs were a little over 150,000 US and 220,000 Australian. When we get up to the mid-category, things accelerate very, very quickly. So in that situation there, your total average costs were about 1.5 million US and about 2.2 million Australian. The explanation of the subcategories is explained in the paper. And then for our mega breach category, these all had really, really big exposures. So average cost there was 4.5 million US or about 6 million Australian. 2 things I'll just finally say on this particular slide here. The numbers that we've done are very, very deliberate. So every cost we've incurred is a real invoice that was either paid or was assessed when a breach occurred. We didn't include business interruption because we didn't have them for all the matters, but in some of the matters, business interruption of over $1 million was claimed. So I suspect that if you look at the entire exposure to the organisation, you'll get numbers that are much higher than this. The other one is too that we're looking with some of our colleagues to kind of have a wider data set and monitor these things for a little bit longer. And my suspicion is when you do that, the numbers will go up again because you'll have more matters that have had a longer period to look at and to germinate. That was all I was going to talk about in terms of the graphs. Did anyone have any questions or issues that they wanted to raise with us?
Thank you for that. My name's Anthony. I've got a question about the concept of harm. It sounds like a very fluffy word, and it's very difficult to understand. You know, if the 2 of us were subject to the same breach, and exactly the same type of data for each of us was stolen or made or disclosed, the impact on us individually could be very, very different. So, do you have any clarity about what harm really means in the legal sense?
Well, that assessment's very relevant. The place in which the person whose data we're talking about, their individual characteristics are relevant to that. and it's these vulnerabilities. But I don't think it's, I mean, I think there are going to be circumstances where lawyers are going to be kept in business trying to determine what we're talking about and whether there has been harm. But I think you can expect the regulator to take a wide rather than narrow approach to that, and where there's any realistic expectation that what a reasonable person would consider was likely to be harm is where we're going to find ourselves. So
I don't know what reasonable people are.
well, I've never met one, but we all think we are, but we never seem to meet one. But no, I mean, that's the legal test, which means it's more of a broad-based effect. You're not going to get a hard and fast answer on that. Certainly in some other jurisdictions, it is more defined and more narrow. But Australia, when it regulates, tends to like to be pretty broad-based.
It's funny because the law can sometimes be very succinct, and then sometimes it can remain deliberately ambiguous, it seems. And the term is actually not just simply harm, it's actually serious harm, or a likely risk of serious harm. So could that be possibly misconstrued as deliberately ambiguous?
I don't think it's
Or
ambiguous.
open?
I just think it's. I mean, I think the legislature had two options when it did this. It either did what I think they've done in some American states and said, if these are the risks, you've got to notify. But I don't think it wanted to do that. I think it recognised that it simply wasn't possible to be so prescriptive about what that harm might be, because data is collected in so many different ways, it's attributed in so many different ways, and and people are so diverse, and that situation can change over time as well. So I think that flexibility and that uncertainty is deliberate.
I might just add, just to give two things there for some context, we had a whole host of bits of draft legislation that came before we got this. Every one of them had a different risk of harm assessment and risk of harm language. And the thing you pointed to is the fundamental challenge here, which is we're told it's not just financial harm, it's got to be reputational harm, it's got to be their individual circumstances and their individual characteristics. But when you're the organisation making this assessment, you're doing it without that information. And my suspicion is, so I worked internationally on a number of breaches with our US team, and companies had to take very conservative approaches. It was really, if it might be a risk of harm, well, we should really be notifying, because you're very, very ballsy if you decide not to do it, and then later on something bad happens. So, yeah, you kind of do it from a situation of lowest bar. If we're over that, we'll do the notification.
Were there any further questions? Okay. Just bear with me.
Just got kind of a bit of a dumb, broad, sweeping question. What is your estimate of the applicability for this legislation across all Australian government and companies, like a percentage figure, like a broad percentage figure that you think this legislation would apply to or be applicable to?
Well, it's going to apply to far more people than it doesn't. In fact, I think it'd be safe to almost assume it applies to you. I mean, if you're a large organisation, yep, and if you're already subject to the privacy principles, it's going to apply to you. If you are a much smaller organisation that falls under that $3 million sort of trading limit, then you've got to look at the information you hold and how sensitive it is, and whether it's going to be of a nature that, even despite your relative size, it's considered, the public risk is considered such that you should be caught by it. And I don't think it's too hard to look at what information that might be. It's anything that really can be applied specifically to an individual and has that personal nature to it.
One more question.
Hey, we're all friends here, so feel free to answer this question openly. I think recently one of our political ministers shared some information as part of a political argument to get back at someone, and they used some of their social security data the government held. And the federal police said, "Oh, nothing to look at here." What would a lawyer think of that? Like, and can you have any comments on that was a breach and the Privacy Commissioner should take action?
That's definitely one for Ben.
I only know a small bit about that, but as I understand it, they actually relied on specific provisions in the statute that enables them. And so if you've got that type of statutory base that's inconsistent with the Privacy Act, you've got some defences to get around it. But I do know it did raise some eyebrows with some of our legal colleagues. So we'll see. I don't know if that story's done yet.
apologies because we are out of time for the next presentation. So if we can all put your hands together and thank our presenters.